Following the exploration of license exemptions for short-term rentals, we now turn to a cornerstone of Arizona property management law, the Arizona Residential Landlord and Tenant Act, ARLTA, codified under ARS Section 33-1301 through ARS Section 33-1381. This act provides the legal framework governing residential rental relationships, ensuring a fair and consistent balance of rights and responsibilities between landlords and tenants. For property managers and designated brokers, understanding ARLTA is critical to maintaining compliance, preventing disputes, and managing residential properties in accordance with Arizona law and professional standards under AAC 4-28-1101. The scope of ARLTA covers nearly all residential rental properties in Arizona, including single-family homes, apartments, condominiums, and mobile homes, where not otherwise governed by separate mobile home statutes. It regulates critical aspects of the landlord-tenant relationship, such as lease agreements, security deposits, maintenance obligations, entry rights, and eviction procedures. However, certain types of occupancy, such as hotels, motels, and short-term rentals of less than 30 days, are exempt under ARS Section 33-13084, reinforcing the distinction discussed in the previous section. One of the most common issues addressed under ARLTA involves security deposits. Under ARS Section 33-1321, a landlord may not demand or receive a security deposit exceeding 1.5 times the monthly rent. This restriction protects tenants from excessive upfront costs and encourages transparency in rental transactions. The statute further requires landlords to provide tenants with a written notice of any deductions taken from the deposit within 14 business days after lease termination or tenant move-out. The landlord must deliver an itemized list of all deductions and any remaining balance of the security deposit. Failure to do so can expose the landlord to statutory penalties, including the possibility of returning double the deposit to the tenant as damages under ARS Section 33-1321E. For example, if a tenant vacates a Tempe apartment on August 1st and the landlord withholds part of the security deposit for carpet cleaning, the landlord must mail the itemized statement and any refund by August 21st at the latest. If the landlord fails to meet this deadline, the tenant can file a claim in small claims court to recover twice the amount wrongfully withheld, as established in Huffman v. Haynes, Ares Curvar App 1988, where the court held landlords to a strict standard of compliance with ARLTA's timelines. The landlord's right to show a property to prospective tenants or buyers is also governed under ARLTA. According to ARS Section 33-1343, landlords may enter the property to exhibit it to potential renters or purchasers, but only after giving the tenant at least 2 days' notice and entering at reasonable times. This protects the tenant's right to privacy and quiet enjoyment while balancing the landlord's right to market the property. For instance, a landlord managing a rental home in Mesa cannot simply walk in unannounced to show the property. The tenant must be notified in writing or verbally. An entry must occur during normal business hours unless otherwise agreed. The rights and responsibilities of both parties under ARLTA are reciprocal. Landlords must maintain the property in habitable condition under ARS Section 33-1324, ensuring essential services such as water, heat, and electricity are provided, and that the structure complies with health and safety codes. Tenants, in turn, must maintain cleanliness, use fixtures properly, and avoid damage to the premises under ARS Section 33-1341. If a tenant withholds rent without lawful justification, such as claiming uninhabitable conditions without proper notice or verification, the landlord may issue a 5-day notice to cure or quit under ARS Section 33-1368, initiating the eviction process if the issue is not resolved. An important feature of ARLTA is that it is enforced through the judicial process, rather than through the Arizona Department of Real Estate. This means disputes between landlords and tenants, such as unpaid rent, security deposit disagreements, or maintenance failures, are adjudicated in the Arizona Justice Court system. Property managers and brokers must recognize that ADRE does not mediate residential landlord-tenant conflicts. Instead, such matters are resolved under the judicial authority granted by ARS, Section 33-1368, which outlines procedures for eviction, also known as forcible entry and detainer actions. Consider an example. A tenant in Glendale fails to pay rent for 2 consecutive months. The property manager issues a written 5-day notice to pay or vacate as required by law. When the tenant does not comply, the landlord files for eviction in justice court. The court schedules a hearing within 5 days, and if judgment is granted, the tenant may be ordered to vacate immediately, with the landlord entitled to possession of the property. This judicial enforcement ensures due process and transparency, reinforcing the rule of law in residential rental management. Review summary. The Arizona Residential Landlord and Tenant Act provides the foundation for all residential rental relationships in the state, defining the rights and duties of landlords, tenants, and property managers. It regulates key issues such as lease terms, security deposits, maintenance standards, and entry procedures. Landlords must return itemized deposit statements within 14 business days of lease termination, give advance notice before entering a property, and maintain habitable conditions at all times. Enforcement occurs through the court system rather than through ADRE, underscoring the importance of understanding and complying with judicial processes. Discussion prompts. Why must a landlord deliver an itemized list of deposit deductions within 14 business days of lease termination? Answer. To comply with ARS, Section 33-1321D, and avoid statutory penalties for wrongful withholding of tenant funds. What distinguishes ARLTA from ADRE regulation? Answer. ARLTA is enforced by the judicial system, whereas ADRE oversees licensees' conduct and professional compliance. Why is advance notice before entry important for landlords? Answer. It preserves the tenant's right to privacy and prevents claims of unlawful entry under Arizona Revised Statutes, Section 33-1343. Closing remarks. Understanding the Arizona Residential Landlord and Tenant Act is essential for every property manager, landlord, and real estate professional engaged in residential leasing. The Act represents the balance between property rights and tenant protections, ensuring fairness and legal clarity in all rental transactions. By adhering to its provisions on deposits, entry, and habitability, property managers not only comply with Arizona law, but also build trust and professionalism in the landlord-tenant relationship.